I've been watching some more of the post office inquiry, and there was a recent witness, and one thing that really stood out was how she was just saying, I just signed this witness statement that was put in front of me. I had no idea what it said. I mean, effectively, her defence to lots of things has been, look, I just signed things put in front of me, because there was some letters she'd sent out, and she's like, that's nothing to do with me. That's not my decision. Somebody else writes them. I just signed it. But this also cropped up with her witness statement in the earlier court cases. And she did seem to be genuinely confused as to, the status of a witness statement, because the barrister put to her and said, you do realise that this is a witness statement. And, there's, you know, a declaration of truth at the end where it warns you about perjury, but she was having none of it. But this has been a common theme in the post office inquiry. People just signing statements, lawyers draft for them. So I thought what we could look at is, first of all, what's the duty on a witness with a witness statement, but also what can lawyers do with regards to witness statements. And I will be criticising a fellow barrister here, only in my opinion, because I think some lines may have been crossed. But I'll explain why that might be, it might have a defence as well. Anyway, witness statements. These are governed by the civil procedure rules. And there's what we call a practice direction that sets out in very plain English, the purpose of a witness statement and how to do them. And there are a couple of sort of basic rules. The main one is the witness statement has to be in the witness's own words. The witness can only talk about the facts of the matter. They're not there to make sort of any arguments or anything like that, or to put forward a particular view, or to put anything irrelevant in. They can only speak as to facts. They have to explain what facts are within their own knowledge. And if any facts aren't within their own knowledge, say, they're hearsay or something they've surmised, they have to put down the source of those facts. They're also supposed to put how the witness statement was taken, whether it was I did this face to face with somebody, well, they wrote it down or typed it out. I typed it out myself. I did this over the telephone. I did it by Zoom. That actually is something that's more honoured in the breach, because I don't think I've ever seen that in a witness statement, but it is in the rules. And then at the end of the witness statement, there is a statement of truth that says, I sign this knowing that if there's anything in it that's not true, I can face criminal penalties for this. So it's all been very, very clear with a witness statement. So does that mean all witnesses have to write their own statements and lawyers can't get involved? No. Lawyers do get involved in witness statements, and there's nothing actually wrong with that. But we are given guidance, and I'll speak from the Bar Council's guidance, but the solicitors' one is pretty much the same. First of all, I want to talk about the difference between taking a witness statement and settling a witness statement. Taking a witness statement is where you sit down with somebody and you say, okay, tell us what happened. And you draft the statement there. You're receiving the information from the witness. Settling a witness statement is where effectively somebody has provided you with the information. They've interviewed the witness and taken some sort of statement, and then they hand it to counsel and say, right, put that in the proper format for court, because there are certain rules about one fact per paragraph and things like that. And also counsel might excise stuff and say, well, actually, that is getting into legal argument. That's not giving factual evidence, so I'm going to cross that out. But then it goes back to the witness to be signed, and it is explained to them. They have to be happy with it. It's their own, it's their own words. They can't just rely on what the lawyers have put in there. So that's the procedure. But that's settling a witness statement. Now, counsel have always been allowed to settle witness statements, but it's only relatively recently that we've been allowed to take witness statements and indeed gather evidence in cases generally, because that was just something that barristers didn't do. Solicitors would be in charge of that, and quite often they'd instruct private investigators or investigating agents to actually gather evidence, and they might use their paralegals to take the witness statements, or just I used to do that. I used to do what we call outdoor clerking, where I'd sit behind counsel in court, but another one of my jobs was going out and just taking witness statements of people. But barristers are allowed to do that now. However, we're not supposed to do it if there is any danger that there might be a challenge to how the evidence was gathered. Now, that's not to say a challenge to the evidence itself. Say, for instance, we take a witness statement from somebody, and in court, the challenge is, that's all lies, that's not true what you were saying there. That's not a problem. But if it was something like, this statement was coerced out of somebody, or that person never actually said that, you've, manipulated this statement, then obviously you'd have counsel in the case having to be cross-examined, and obviously that's a situation to be avoided. So the rule is that if there is any chance, and even if you're like 23rd junior on a massive case, you're not supposed to actually get involved in the evidence gathering yourself. That's just in case everybody else got wiped out and all of a sudden you had to take over the trial. So we can do that, but when it comes to settling, like I say, it is just putting things, into the correct format and just correcting some of the language. But what can go in and what can't? Well, it's obviously got to be everything factual. Now, but one thing we are entitled to do is not anticipate cross-examination. So we don't necessarily have to put in anything there that is negative to our case. Now, that's obviously different to disclosure, where you have to disclose documents, if they might harm your case. But when it comes to giving evidence, you don't have to make the other side's arguments for them. I mean, the whole point of disclosure is they're supposed to spot what they want to challenge, and it's for them to challenge it in cross-examination. However, you can't excise something if it would be misleading. So say somebody's puts in fact A, which is technically true, but you don't get the actual real picture unless you also know fact B, and counsel says remove fact B, then that would be a breach of the code of conduct. So what's happened in the post office case? Well, counsel just got them to excise from witness statements the fact that the Horizon system was faulty, because he said that would just undermine the case, and which, that's so against the rules. And when it was put to him, he just sort of effectively said, oh, I had a bit of a mind blackout, I wasn't really thinking. And, he obviously said, I accept now that was wrong. And I think he might be in some trouble for that, because while there is an argument that, you can say, no, that should come out of the statement, material like that, where it's directly addressing, a point the defence have raised, then the argument is, no, that's misleading. I mean, if he wanted to defend himself, he could say, well, no, I left that out and it's for the other side to put to cross-examination, no, the computer system was faulty. And then that witness would have to answer truthfully, yes, that's right. Because that's another thing, you see, even if something's not in a witness statement, if somebody gives an answer that we know is inconsistent with our instructions, so they've told us everything that happened, and we've said, well, only half of that actually has to go in and is relevant, but then in court, they say something that goes against something they said, even one of the irrelevant bits, then, we'd have to have words or withdraw. And to end this ramble, I'll leave you, because this happened with Oscar Wilde. The trial of Oscar Wilde, the one where he was on trial. It was a brilliant piece of cross-examination, and I always recommend to young barristers read the book, the Penguin Great Trials series, because the first question was literally just, how old are you, Mr. Wilde? And Oscar Wilde, being so vain, gave the wrong age. And then that forced his own counsel, because he knew the truth, to have to stand up and say, actually, that's not correct. So that's just brilliant, and that's about knowing your witnesses. Knowing somebody's so vain they'd give that answer, and knowing by asking that question, the first thing that would happen in cross-examination is the defendant's own barrister would have to stand up and say, sorry, he's not telling the truth. So there you go. That's the genius of advocacy. Anyway, hope you found that interesting, well, vaguely interesting, vaguely useful. And, I'll come back to this as to what sanctions might happen to the lawyers in this case, because I've been monitoring what the SRA and the BSB have been saying. So yeah, there will be future videos on this. And if you want to see those, consider subscribing, because then you'll get notifications, or maybe you have to press another button or something like that, or just click like I say, under no obligation to, but it's nice when you do.